In this segment, we're going to discuss the landmark Supreme Court case known as Marbury v. Madison, the case which formed the basis for judicial review for all courts in the United States. The case was heard and decided in 1803, and it is the critical case, or one of the critical cases, for defining the boundaries between the executive, legislative, and judicial branches. The official description of the case goes like this. The case resulted from a petition to the Supreme Court by William Marbury, who had been appointed Justice of the Peace for the District of Columbia by U.S. President John Adams, and duly confirmed by the U.S. Senate. But his commission had not been delivered. Marbury petitioned the Supreme Court to force the new Secretary of State, James Madison, to deliver the documents. The court, with John Marshall as its Chief Justice, found, firstly, that Madison's refusal to deliver the commission was both illegal and repairable. Nonetheless, the court stopped short of compelling Madison by a writ of mandamus to hand over Marbury's commission, instead holding that the provision of the Judiciary Act of 1789 that enabled Marbury to bring his claim to the Supreme Court was itself unconstitutional, since it purported to extend the court's original jurisdiction beyond that which Article III established. The petition was therefore denied. Now that simple, dry, legal language hides one of the most important legal cases, perhaps even the most important legal case in the history of the U.S. Supreme Court. And the story behind it is so dramatic that it rivals anything in the constitutional crises that have ever been discussed in the United States. The story goes like this, and the story may sound familiar if you're at all used to a lot of controversy surrounding national government, because the controversy then was at least as pronounced as the controversies we're going through today. It worked like this. The country had long been divided from the American Revolution on, through the Articles of Confederation, through the ratification of the U.S. Constitution, by a variety of groups. They had boiled down by 1800 to a couple of major groups, those who called themselves the Federalists, led by John Adams and Alexander Hamilton, and claiming, not entirely accurately, but fairly accurately, George Washington as their principal leader. And the followers of Thomas Jefferson and James Madison on the other side, who called themselves Democratic Republicans. Their party's name was subsequently shortened to the Democratic Party, but at that point they combined Democratic and Republican together. They had a controversy. They had fought over the election of 1796, which John Adams narrowly won over Thomas Jefferson. They continued to fight throughout the Adams administration, and there was a massive controversy surrounding the 1800 presidential election that Thomas Jefferson won. Thomas Jefferson won the election, and it was approved in February of 1801. He took office at that time. The swearing in for presidents came on March 4th, 1801. In that narrow, about 2-week window, the Federalists, alarmed at the fact that they'd lost the presidency, had lost a lot of strength in the legislature, were convinced to hold on to the courts. So at the last minute, what was known as a lame duck session of Congress, they pushed through a Judiciary Act of 1801, revising the federal court system, creating a bunch of new federal courts, and creating a number of federal justices of the peace, one of whom was William Marbury. They passed the act. John Adams signed the act. John Adams appointed a bunch of judges. The Senate confirmed them, all within a 2-week period. The only thing that didn't happen is there wasn't enough time for the commission, the signed commission by the Secretary of State, to reach all of the judges. There was no overnight express. There was no, it took weeks sometimes for mail to reach one part of the country to another, and that happened. there were a number of commissions duly signed, duly confirmed, duly nominated by the President that sat on the Secretary of State's desk. Now, here's where the personalities come in. The Secretary of State under John Adams was John Marshall. And he had, by this point, been appointed, though not yet taken office, as the Chief Justice of the U.S. Supreme Court. He was continued to serve as the acting Secretary of State. John Marshall, who was unable to get the commission to William Marbury. When President Jefferson came into office, he ordered his Attorney General not to deliver the commissions because James Madison hadn't yet arrived. When Madison arrived, Madison was similarly told, we're not going to deliver these commissions. Why? Well, Jefferson was angry, and the Democratic Republicans were angry because the Federalists had appointed all of these last-minute judges. They were called midnight judges by the Democratic Republicans, and despite the fact that they had all met all of the legal constitutional responsibilities, Jefferson hated the fact that so many judges had been appointed to the last minute. He, in fact, ordered and pressed for the adoption of a new Judiciary Act of 1802 to repeal the Act of 1801, and in that he put off a meeting of the Supreme Court by law to prevent the old court from sitting and deciding these matters before the Judiciary Act was put into place. All of this resulted in the delay of the case from 1801 until 1803. In 1803, William Marbury sued. He sued under the Judiciary Act of 1789, which he had reason to believe was valid since it had just been revalidated by Jefferson and the Democratic Republicans themselves. Marbury sued for a special provision, or a special document called the writ of mandamus, an order from a court to a civil officer of the government to do something they're supposed to have done anyway. It's a valid court order, and presumably a serious legal action could be taken against anyone who did not honor a writ of mandamus. Marbury went to the Supreme Court directly without going through any lower courts at all, because he believed, under the Judiciary Act of 1789, that the Supreme Court had original jurisdiction. That is, you could bring the court case directly to the Supreme Court without going through any lower courts. Well, this was a remarkable event. Remarkable on several levels. First of all, you have John Marshall and Thomas Jefferson, cousins, who are at odds with one another. You have John Marshall, as Secretary of State, failing to deliver a document. You have John Marshall, as Chief Justice of the Supreme Court, sitting in judgment on a case in which he had a paramount role. He's in effect sitting in judgment on whether he, as Secretary of State, had acted properly in not getting the commission to Marbury. Several of these features, like that, would probably have been called a conflict of interest, although with conflict of interest, if you're acting in accordance with the law, and there's not a serious question, it may be that conflict of interest is not particularly relevant. Nonetheless, we had a very small nation, with most of the major political actors knowing one another fairly well. So this was not a dispute between strangers. This was very much a family affair. Now, the situation that confronts us is this. It's not, Jefferson was undoubtedly wrong, Madison was undoubtedly wrong in not delivering the commission. Marbury acted under a law that had been passed, acted under an appointment that had been made by a legitimate sitting president. He'd been confirmed by the Supreme Court, and his document had been signed by a sitting Secretary of State. All of it's legal. Much of this is wrong on Jefferson's part. But what is Marshall going to do? If Marshall rules that Marbury is to get his commission, and if he orders Madison or Jefferson to give the commission to Marbury, there's a great chance that they will simply refuse. John Marshall has no army. He's not commander-in-chief. All he has is the authority of the court to work with. And that authority will be severely damaged if he hands down a decision that Jefferson is wrong, that Madison is wrong, and then they simply refuse to honor it. The Supreme Court as an institution will be destroyed. So Marshall hits on one of the best stratagems that's ever happened. He looked at the Judiciary Act and he decided that the Judiciary Act that allowed Marbury to send a writ of mandamus, a request for a writ of mandamus directly to the Supreme Court, was unconstitutional. Therefore, he was able to decide Marbury is entitled to the commission. Madison is wrong and illegal. Jefferson, by extension, is wrong and illegal. So he wins the only political point he can win. And then he succeeds in saying, but of course we can't do anything about it because Marbury came to the wrong court, acting under a law that he thought was valid, but it turns out, alas, it's unconstitutional. Now what Marshall did with this act was to upgrade the authority of the Supreme Court by clearly and unmistakably saying something that had been argued before, that had been discussed before. He's saying the Supreme Court can overrule an act of Congress signed by a president. It can use judicial review to have one branch of the national government, the judiciary, declare an action of other branches of the national government unconstitutional. From that moment forward, the authority of the court had been raised. And who was furious? The winner. The winner of the case in the Supreme Court was James Madison and Thomas Jefferson. And they were furious because they realized that what Marshall had done is simply raise the authority of the Supreme Court higher than the President of Congress, threatening the entire Democratic Republican regime. But what were they going to do about it? If they wanted to defy Marshall, what would they have to do? They'd have to give Marbury his commission, which is what they hadn't done in the first place and what they were not about to do. A remarkable case, filled with all kinds of drama, and certainly it filled the drama of the political actors of the day. A remarkable case that set all of the courts in the country on the path of judicial review. Because if the Supreme Court could declare things unconstitutional, by extension all federal courts, and then even state courts were in the capacity to decide that the Constitution was trumping an action or a law passed by any of the legislatures in the country.